said earlier in chambers, obviously this wasn't the best course of action for Mr. Ransky when the officers got there, and while they were looking for Cody, she obviously did not want to let them arrest him. She didn't want him to go away. It was not a great call. It was not the right call. It's obviously why she pled guilty to this. She's currently, as you're aware, she has a case across the street in juvenile court with JFS. They're handling this. They're handling the issues with the children, with her children. It's still in progress. It's still ongoing. She wants to move forward from this case, Your Honor, and focus on JFS. They have a case plan. They have things that she needs to do with them. My understanding, she has been doing, but needs to do more and needs to keep doing. It's the standard way across the street for JFS. They want to see you do things, and they want to see you do them for a while to make sure that you are actually doing what you need to do, and they feel that you will continue to do so, not just for a week or two or a month. Your Honor, we ask you to take these things into consideration. The fact that despite her being sentenced today and being on probation with here, she is still dealing with the courts directly as far as juvenile court in regards to the children, which I think kind of should be at the root of all of this. It should be in her thoughts primarily. I mean, she needs to get herself right, but she needs to do that not just for herself, but for her children, because their children need a father, they need a mother, they need both. She needs to be the mother half of the children. She needs to start making the correct decisions for them because of being their mother. Your Honor, we ask you to allow Mr. Ransky to be on community control, to be able to be out of jail and doing what she needs to do to work with JFS, to work to better herself. Just consider these. Thank you.
Thank you. Mr. Ransky, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say?
No.
Okay. Mr. Langmack, anything else?
Nothing further, Your Honor.
Ms. Linden?
Thank you, Your Honor. Your Honor, although the state's not opposed to, community control sanctions, we do believe that some jail time is appropriate. I found it interesting that in the psych evaluation, there's no mention of any kind of drug or alcohol use at all, but clearly there was in the pre-sentence report. In the pre-sentence report, she says that she has been sober for 6 months, but that she last used in May, and I know my math in this court isn't always the best, but it means that there was some additional time in there that she was using. The focus that she has so much on what happened with police in the past, she completely misses the point that this is a situation where they were coming to get Cody because he had severely burned her child, who's 7 years old, in the hand. And so it's not as if she didn't know why they were coming, and even if they wanted just to come and talk to him, to lie to the police was not appropriate. And so looking at this and looking at the history and what she talks about with the way that she was treated by her stepfather and what she went through, I guess I'm a little concerned that perhaps maybe her thinking, and especially keeping Cody safe while not keeping her children safe, there's an issue there. So we are asking that there be some jail time imposed. Again, we're not opposed to community control. She does have 12 days of credit for time served. Thank you.
Thank you. This court has reviewed the pre-sentence report, investigation, the psychological evaluation, consider the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in court by Mr. Langmack on behalf of the defendant, prosecutor, and the recommendation. I afforded the defendant an opportunity to make a statement. She chose not to, which is fine. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, factors indicating conduct is more serious Other relevant factors, just the prosecutor touched upon this, but you're obstructing the police in investigating a case involving abuse to your children. And the whole reason you're giving for doing that is that the police didn't help you when you were growing up and you were abused and they didn't help you.
No, and that's not.
That's what you said.
Well, that was a reason, but it wasn't the reason.
Well, I'm speaking now. I gave you a chance to speak and you chose not to make it. But you've said it repeatedly in your pre-sentence report. You even wrote it down. Well, I don't like police officers. Growing up, they did nothing to help me when I was abused. She states she lied to the police because she does not trust them. She reported while growing up she was physically abused by her stepfather and the police did nothing to help her. You wrote that down. So now the police are at your house trying to help your kids who are abused, and you're preventing them from doing it. The overall circumstances around this obstructing make it more serious than the normal obstructing. When the police are there to arrest the person who abused your children and you're protecting the abuser, and trying to let him stay in the house, it makes it much more serious. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions and juvenile delinquency adjudications. The nature of those causing concern because they are all of a violent nature. I mean, the juvenile delinquency is domestic violence, domestic violence, domestic violence, domestic violence, assault, aggravated menacing. As an adult, you have disorderly conduct and a domestic violence. Now, I will note that the last offense of that domestic violence I just referred to was 11 years ago. It's the last one, but there was a petty theft in between that. A few years ago, there was a period of time where there wasn't anything. There's absolutely no genuine remorse in regards to the offense here and her conduct here. She doesn't regret what she does. She doesn't have any remorse about it. She had a horrible attitude with the probation department when she was with them. Why don't you work? You said you want to get your kids back, and that's why your focus is getting your kids back. And that just happened. Your kids were taken away just this year. You haven't worked. Are you capable of able to work?
Am I allowed to talk now?
Yeah.
Okay. No, I can't work right now
Why can't you work?
because I have a lot of issues that I need to take care of, and I was trying to.
Okay, well then she's not going to be amenable for community control sanctions because one of the conditions of your probation, if you're put on probation, you have to get employment.
Yeah, it's not going to happen.
Huh? That's not going to happen?
It wouldn't happen, though.
I'm sorry?
Yeah, she's in prison, otherwise.
That's not going to happen. That's what
I
she's
don't even have a home right now. How would I get a job?
Well, you can try to get one.
All right, well then we're going to shift gears here.
She's in prison.
I find the defendant is not amenable to available community control sanctions. It's clear she's not going to work with anybody. She wasn't cooperative. She was rude. She's right here says she's not going to be able to comply with the conditions of her probation. She's not amenable to available community control sanctions. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 6 months. Should be given credit for 12 days she's already served. Need to advise you upon your release from prison, you could be placed on post-release control for 2 years. If you are and you're violating any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 3 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court just approves the defendant's placement in program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. I mean, there's no reason the defendant can't work. There's no physical reason. There's no other issues like that. She just says it's not going to happen. I'm not going to waste everybody's time here. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Mr. Langmack?
Oh,
Wait.
the other remaining.
The other count will be dismissed. Mr. Langmack?
No, Your Honor.
All rise.